Welcome to the Deep Dive. This is where we take the sources you send us and, well, we dive deep, pulling out the key things you really need to grasp.
That's the plan. And today we're looking at a situation where, well, where getting justice seems to hinge completely on how effective the system is, or maybe how ineffective it's been.
Yeah, effectiveness is definitely the word here. We've got legal docs, constitutional law studies, news articles, court filings, all focusing on one specific case.
That's right, the case of Victor Sandy versus Trinidad and Tobago. And our mission really is to unpack the core problems and follow the struggle for a just outcome. We're really honing in on how these efforts highlight why an effective legal process is so critical it's become our central concern.
Okay, so where does this all begin? It seems to kick off back in 2014.
It does. Victor Sandy and some other estate constables, they were let go retrenched from RBC Royal Bank in Trinidad and Tobago.
The reason given was redundancy. Their jobs weren't needed anymore. Or so the bank claimed.
Exactly. And that claim of redundancy itself, well, it becomes a bit of a sticking point later on, questioning the fairness and effectiveness of that initial move.
Right. So after they were retrenched, the State Police Association, the EPA, got involved.
They referred the dispute to the Ministry of Labor. Now, this is interesting. The EPA's own internal records, they actually show the date of that referral.
Which was?
May 7th, 2014. And you really need to keep that date in mind.
Okay, May 7th, 2014. Why is that date so critical?
Because what happens next really shows a breakdown in, well, the effectiveness of the whole procedure laid out in law.
Ah, okay. So this is where the procedural stuff starts to look a bit shaky.
You could say that. The Ministry of Labor, they were supposed to issue something called a Certificate of Unresolved Trade Dispute.
And that certificate is basically the green light to take the case further to the industrial court.
Precisely. It's a required step. Without it, you're kind of stopped in your tracks. Now, the law, the Industrial Relations Act, it gives the ministry 14 days to issue this.
14 days, okay? Seems straightforward.
But they didn't issue it until May 8th, 2015.
Wait, 2015? That's a full year later, not 14 days.
Not even close. It was 229 days after that 14-day statutory limit had expired.
Wow, 229 days late. That can't be just a simple admin error, can it? What's the implication?
Well, the legal argument is pretty strong.
Yeah.
That kind of massive delay could make the certificate totally void, invalid from the start.
And if the certificate is potentially invalid,
then the whole foundation for taking the case to court is undermined. It's a major blow to the effectiveness of the process right out of the gate. How can you get an effective remedy if the permission slip, so to speak, is fundamentally flawed?
Okay, so that's a huge red flag about effectiveness already. But the problems didn't stop there, did they?
No, far from it. So eventually, the case does get before the special tribunal. They initially took jurisdiction, started hearing it in April 2015. You'd think, okay, finally, progress.
Really?
But then in January 2018, nearly 3 years later, they just dismissed the case.
Dismissed it? On what grounds? Was it related to the certificate delay?
Not directly. They dismissed it based on something they called a fabricated branch board requirement.
A fabricated what? What does that even mean? A branch board requirement?
That's the thing. According to the sources we looked at, this requirement had absolutely no basis in law. It wasn't in the act, wasn't argued by either side. It just appeared out of nowhere in the dismissal ruling.
So they essentially invented a reason to throw the case out.
That's the allegation, and it speaks volumes about a potential breakdown in effective legal process. If a tribunal can just create new, baseless hurdles, well, how is that a fair or effective system? It completely undermines predictability and justice.
That's incredibly concerning. And it gets worse, right? There's something about an affidavit.
Yes. The secretary of that same special tribunal allegedly filed a sworn affidavit later on, claiming the tribunal had never actually exercised jurisdiction, never took the case on properly.
But didn't you just say they held hearings starting back in 2015?
Exactly. The hearing transcripts apparently show clearly that they did exercise jurisdiction. So this affidavit seems to directly contradict the actual record of the proceedings.
Filing a false affidavit. That's perjury, isn't it? That's incredibly serious.
It certainly appears to be a very serious misrepresentation. And think about the impact on effectiveness. If you can't even trust the official court record, if it's being actively distorted, how can you possibly achieve an effective resolution? It poisons the well.
Absolutely. So faced with all this, the delay, the fabricated rule, the questionable affidavit, Victor Sandy started arguing his constitutional rights were violated.
Understandably so. The first one he pointed to was Section 4B of the Constitution of Trinidad and Tobago,
which guarantees
The right to the protection of the law, basically the right to a fair and functional legal system.
And how is that allegedly breached here? How is the protection ineffective?
Well, the argument connects all those points we just discussed. The massive delay with the certificate, the dismissal based on a made-up rule, and crucially, the state's later failure to actually do anything, even after higher courts ruled in his favor. It all paints a picture of a system that wasn't effectively protecting his rights. Protection implies timeliness and fairness, and those seem to be missing.
Okay, that makes sense. Then there's Section 5, 2E. What right is that?
That's the right to a fair hearing. Due process, essentially.
And the issues there, still linked to effectiveness.
Very much so. Two main points here. First, the claim is that Victor Sandy was sort of shut out of decisions about his own case because of these. Let's call them unauthorized representative, acting supposedly on his behalf.
Unauthorized representatives. We'll need to come back to that.
Definitely. And second, even when he won appeals later on, he argues he's been denied actual redress. No compensation, no proper rehearing ordered. So you might get a ruling saying you were right, but if nothing happens as a result, was it really a fair hearing in the practical effective sense?
A hollow victory, perhaps. And there was one more right mentioned. Section 4A.
Yes, the right to respect for private and family life. And in this context, it's being argued that this includes a sort of property right in your own identity, your legal name.
How does that fit in? Unauthorized use of his name.
The allegation is that these private agents, we should name them, Harrison Thompson and Robert Ramutar, were using Victor Sandy's name on legal documents, filings, things like that, without his permission.
So using his identity in a legal fight he wasn't fully controlling.
That's the claim, that using his name without consent infringed that right and, importantly, made it harder for him to effectively manage his own legal situation and pursue justice the way he wanted to.
Okay, let's talk about these individuals, Thompson and Ramutar. Who were they acting for, supposedly?
They were identified as private agents acting for the EPA, the State Police Association.
But you mentioned unauthorized earlier. What's the issue with their authority?
The core claim from Victor Sandy is that they were never actually given the mandate by the EPA members. Like there was no proper vote or resolution authorizing them to act, especially not to the extent they did.
And what extent was that?
Well, besides allegedly using his name without consent, he also claims they went and hired private lawyers, chancery chambers again, without his knowledge or agreement.
So lawyers were hired supposedly for him, but he didn't know about it or agree to it.
That's the allegation.
Yeah.
And you can see how that would massively impact his ability to effectively run his own case, right? If other people are making decisions, hiring counsel, using your name, you've lost control.
It certainly muddies the waters regarding effective representation and control over one's own legal battle. But despite all of this, chaos, really. Victor Sandy actually won in the higher courts.
He did. Quite decisively, in fact. Both the Court of Appeal in Trinidad and Tobago and then the Privy Council in London, which is the final Court of Appeal, ruled in his favor.
And what did they say? Were they critical of the tribunal?
Highly critical. They described the special tribunal's reasoning for the dismissal, that fabricated branch board thing, as manifestly bad. Pretty strong language from high courts.
Manifestly bad. Okay, so clear victories. Surely that led to an effective resolution, finally. Case closed, justice served.
You would absolutely think so. I mean, rulings from the highest courts heavily criticizing the previous decision. That should be it.
But it wasn't?
Apparently not. This is where the issue of effectiveness just hits you like a brick wall. Despite those clear, unambiguous rulings, the claim is the state hasn't followed through.
How so? What hasn't happened?
No compensation has been paid, as was implied or ordered by the rulings,
Yeah.
and the matter hasn't been sent back to a properly constituted tribunal for the actual hearing on the merits that he should have had years ago.
So he won on the process, but hasn't actually gotten the substance of his case heard or received any remedy.
That seems to be the situation. And this is precisely why our focus has shifted so strongly to effectiveness. What good are legal victories on paper if they don't translate into actual tangible justice? How effective is a system where even the highest court orders are seemingly ignored?
It's, astounding, really. It makes you question the whole point. If winning doesn't mean winning in practice, what does that say about the system's overall effectiveness?
It raises profound questions. It suggests a serious disconnect between legal pronouncements and real-world outcomes. Making those victories effective is the challenge now.
And let's quickly loop back to the very beginning, the reason for the retrenchment. Redundancy. There was a wrinkle there too, wasn't there?
There was. The sources suggest that after Victor Sandy and the others were let go because their jobs were supposedly redundant, RBC allegedly went and hired new officers.
To do what?
To perform the same functions, the very jobs that were supposedly no longer needed.
Right. If true, that completely undermines the entire basis for the retrenchment, doesn't it?
It certainly casts significant doubt on it. It suggests the initial redundancy might not have been genuine, adding another layer of potential injustice, and questioning the effectiveness and good faith of the entire situation right from square one.
Okay, so given this incredibly long and frustrating journey, what is Victor Sandy asking for now? What's the goal in the current high court action? He's still fighting.
Oh, yes. He's seeking several key things from the High Court, all aimed at finally getting an effective outcome.
Like what specifically?
He wants declarations. A formal court statement saying that the original certificate of unresolved trade dispute was void because of the delay.
Okay, validating that initial point about effectiveness.
Exactly.
Yes.
Also, a declaration that the special tribunal's dismissal was unlawful, hitting back at that fabricated requirement. And a declaration that using his identity without consent was a breach of his constitutional rights.
So getting the record straight on the major failures, is he seeking compensation too?
Absolutely. He's seeking various types of damages, compensatory damages for the financial losses he's suffered over all these years, constitutional damages for the violation of those fundamental rights we discussed.
And anything else?
Yes, also aggravated and exemplary damages. Aggravated for the distress and injury to his feelings caused by the way this has been handled, and exemplary damages, which are intended to punish and deter this kind of conduct in the future.
So it's a comprehensive attempt to finally hold the system accountable and achieve a truly effective resolution.
That's precisely the aim. After all this time, all the procedural roadblocks, the questionable actions, the unfulfilled victories, it's about making the legal process deliver actual effective justice.
So wrapping up this deep dive, it's a really stark picture, isn't it? Procedural failures piled on top of procedural failure.
Serious allegations of constitutional rights being breached.
And this ongoing, grinding struggle for justice, for effective justice, even after winning at the highest levels.
It really lays bare how complex these systems can be and how vulnerable they are to, well, ineffectiveness. Even when rights are vindicated on paper by top courts, the journey from that ruling to actual practical relief can be incredibly difficult, sometimes seemingly impossible.
The gap between principle and practice.
Exactly. And Victor Sandy's case forces us, and hopefully you listening, to think hard about how we ensure that gap is closed. Our focus has to be on making sure effectiveness isn't just a buzzword, but a reality.
Which leaves us with a pretty big question to ponder, doesn't it? What does it actually mean for a legal system to be truly effective? Is it just having laws? Or does it demand rigorous adherence to fair processes, real accountability when things go wrong, and ultimately ensuring that a legal win actually translates into meaningful, tangible justice on the ground for the person affected?
That's the core issue. When a system falls short, as it appears to have done repeatedly here, even after those hard-won legal victories, what are the real human consequences? It's something Victor Sandy is still grappling with, and it challenges all of us to think about what justice in its most effective form should look like.